years of age. He's on Social Security disability, Judge. I don't see any criminal history for Mr. Pollard, Your Honor. He lives in the city, does have a child. Your Honor, this alleged incident occurred back in 2020. So it's some 4 years ago. Obviously, it's a serious case, obviously. But it's 4 years old, Judge. He has no priors. I'm asking respectfully for a reduction in bond. The bond is $250,000 cash. Judge, I know the court will impose a GPS tether. I already know that, Judge. My client, in fact, Judge, he has a tether already on. He has a tether already on. Let me be clear about that. There's a misdemeanor, and I apologize, Judge, if I said something wrong initially. There's a misdemeanor that he has the tether for, so it's a misdemeanor.
Okay.
Your Honor. And he does a lawn care service, so he does have some work that he does, but the court doesn't have to worry about tether. I'm just asking for a reduction in bond to either a high some type of 10% bond. I think 250,000, Judge, is excessive. Thank you.
Okay. Mr. Prosecutor.
Judge, the defendant on the screen today in the top left, he's being charged with sexually assaulting a 7-year-old. The assault allegedly happened at his house in his bed. Your Honor, this is an individual who allegedly is self-proclaimed part of the tribe of Judah. This is also an individual that I actually had the opportunity to watch the arraignment regarding the defendant in this case, gave the magistrate such a hard time that multiple magistrates actually ended up having to handle the matter because he wouldn't give up his name or his identity. Now, being charged with this and now knowing what his past is like, I may refrain from giving a magistrate or a judge my name as well. Because, Judge, the situation that Mr. Reagan is talking about that the defendant's involved in right now, it has to do with selling and furnishing alcohol to minors, to a 12-year-old and 14-year-old. It actually originally began as a criminal sexual conduct first degree where the defendant allegedly was having sex with the 12-year-old. But, Your Honor, based on apparently the idea that somebody didn't appear at a hearing, it was reduced to the selling and furnishing of the alcohol. So he has an ongoing matter right now, Judge. He's on bond. We have this particular matter, allegedly, where this individual ended up touching a 7-year-old's vagina. We have corroboration to that, Judge. And, Your Honor, with all due respect, the way that the people see this defendant based on previously being charged, now being charged with another CSE first degree, we find him to be a predator. Not only that, Judge, we find him to be mentally unstable. He's currently on a case regarding minors, 12 and 14 years old, and just plain and simple, Judge, we find him to be a danger to the community. Therefore, Judge, we do feel as though a high cash bond is appropriate. We do feel as though the magistrate got it right here in terms of the $250,000 cash, not just to this particular complainant, but kids, all kids. This is one of those individuals where we feel as though he poses a danger to everybody.
See, where we haven't heard their arguments of counsel, where this gets a little dicey for concerning bond is that we have a situation where the defendant allegedly, I guess an 18-year-old comes in town to visit with him for her birthday. She turned 18, so she comes to see the 37-year-old. Who she's been in a long-term relationship with for the last 3 years. So I guess he would have been 34, starting the relationship with the 15-year-old. Allegedly, she talks to a friend and they come over and the 7-year-old is over. The girl comes and finds the two of them in the bed, and then the mother contacts a person asking who is this Kevin guy, because her daughter says he touched her vagina. So, and then we have another case of furnishing alcohol to 12-year-olds. and whether there's sex there or not sex there, we have a pattern that's a little bit it's a little bit concerning. It's a lot of minors, a lot of alcohol, a lot of sex allegations, a lot of molestation allegations, a lot of flying people in who are kids and teenagers. And so we're real concerned about this. So the $250,000 bond is an unaffordable bond. And so the court does find that this defendant is a danger to all kids. He's just a danger. The court is going to disagree with the magistrate on this, and I know the magistrate or magistrates had some issues with this defendant, and they used the information that they had at this time to come up with the $250,000 bond. But the court does find that Mr. Pollard poses a great danger to the community, and a $250,000 bond is unaffordable, but it's not enough. It's not enough. So what we're going to do is we're going to add some to it to make sure he's incapacitated. But if he posts a bond, then that means we know that he'll appear for court. So the bond is going to be increased to $1 million, and that'll be $1 million cash. If he makes the $1 million, then he'll be placed under house arrest with GPS tethering. And Mr. Pollard is not to have any interactions with anyone under the age of 18, whether they're family, whether he knows them. He's not to be around anyone under the age of 18. If he is, that will violate his bond. Thank you.
So, Judge, the bond was $250,000 cash.
Yeah, and now it's $1 million cash. Now it's $1 million cash. Okay. It's $1 million now. It's $1 million now.
Okay, because he's on Social Security disability now. Can't afford.
I understand, but the court finds that Mr. Pollard, it may be some serial action is going on right here, and I don't really know if he's like a serial rapist. I don't know if there are other children that he just lays in the bed with allegedly and touches, or there's other 12-year-olds, or if he's flying other 18-year-olds out to celebrate their birthday. I'm not sure. So what we have to do is we're going to err on the side of caution and make sure that Mr. Pollard is not able, at least right now, to be able to engage or even be charged with engaging in these type of activities.
Yeah, no, Judge, I get it. I know it's rough when the allegations are from January of 2020, but the prosecutor doesn't charge until January 24. I mean,
yeah, it's when it looks like it wasn't until October 14th of 2023 when the mother called asking, who is this Kevin guy? So that we just kind of got that information, and I'm not sure when the 12-year-old. I'm not sure when all the 12-year-old and the alcohol, when that happened. So it's a lot, Mr. Reagan, and so the timeline may get a little bit jumbled. But it's a lot of kids, teenagers, alcohol, sex, molestation. It's kind of blending, and so we're here where we are.
Yes, sir.
Right, thank you, Mr. Pollard. You can leave, sir.
Carnell McCra, appearing in appropriate persona.
All right. It's my understanding, sir, you filed a motion to have Judge Bryant disqualified from the case. Judge Bryant denied your motion, and essentially your motion was appealed up to the chief judge, which is me. Is that correct, sir?
That's correct.
Okay. Argument.
Well, the argument is, sir, under Michigan Code of Judicial Conduct, the judge is in violation of Canon 1 and 2 because I'm here falsely accused for a 21-year-old warrant. And I tried to speak, and she acts like Judge Judy. She just constantly cuts you off, is threatening, so far as be quiet. Canon 2, it says public confidence in the judiciary is eroded by irresponsible and improper conduct by judges. A judge must avoid all impropriety and appearance of impropriety. A judge must expect to be the subject of constant public scrutiny. A judge must therefore accept restrictions on conduct that might be viewed as burdensome by the ordinary citizen and should do so freely and willingly, Judge. And I come into court very respectful. I'm a 51-year-old man, and I respect the system. but I'm feeling that I'm being given, disrespect. I'm being silenced. I mean, I have a right under the free speech to petition the court for redress of grievances and things of that nature. And if you look at the TV show Judge Judy, this is how she acts, Judge. Totally wrong. And she asked me, what did I want to do with the case? I said, I would like to challenge jurisdiction because I went to prison in '02 for 15 years and 8 months. They had under the rule, it's, I believe, for misdemeanors, 40 something days, for felonies is 6 months. So I request that the prosecutor prove its authority in bringing these charges so late. And I have been home 6.5 years, productive in the community, no problems. And I'm trying to do right, Judge. I made past mistakes when I was a young man. And I'm just being treated like I'm just a criminal. I'm supposed to be innocent until proven guilty, right? So I'm not trying to disrupt this court. I'm not trying to cause you guys hardships or anything, things of that nature. And my due process is being violated, Judge. That's all. I want to just get this case so it wouldn't be left alone. I'm a grandfather. I have children. And their DPD has retaliated against me, Judge. And I know this is a Detroit police court. And I would like an investigation as to things that's been going on by the prosecutor's office, because Kim Worthy and her subordinates are retaliating against me. There's actual proof. At this point, I don't know if you're familiar with Bill Proctor. He's representing me in this matter and another matter so far as investigations for years of, hardships and tyranny committed against me by the system here in Wayne County. So this is all I want, a fair shake judge, a judge who's going to give me due process and give me what I'm entitled to according to law. And that's it, sir.
Okay. Ms. Ritter, would you like to respond in any way?
Judge, the only response that people have is that this is a case from 2002. It's a misdemeanor assault and battery case. Judge, from my recollection of the prior hearing with Judge Bryant, I do believe, if I'm not mistaken, that it was an arraignment process. And as the court was trying to proceed with the process, I do remember Mr. McCreary interrupting the judge while she was trying to make the record. But the people have not gotten to the point where, because Mr. Carnell was disruptive during the proceedings, the people didn't get to the point where there was another pretrial date set where the people could actually see if we were able to move forward on this 2002 case, Judge.
I have a rebuttal.
Yes.
Okay, Judge, I would like you, if it's possible, I know you guys are on Zoom, so you should have access to recordings of these hearings and things of that nature. I believe that the prosecutor just fabricated facts to you because I was not rude to this lady. All I asked her is, she said, what do you want to be done with this case? I said, I would like to challenge jurisdiction. And Michigan and federal law requires once jurisdiction is challenged, it must be proven. How is it that the prosecutor knows statute of limitations? They're licensed. I'm not licensed. I've studied for years in prison. And they don't know that there's a statute of limitations. This is vindictive prosecution because of my complaints against Kim Worthy, Your Honor. And the record will reflect the evidence. And I object to her statements. All right.
Court having had a chance to hear the arguments of the moving party, as well as the arguments of the prosecutor. The moving party is asking for a recusal or to have Judge Bryant disqualified based on Michigan Canons 1 and 2, based on that she is biased, as well as is not allowing a person to be able to basically argue their case. The moving party is stating that he wants to challenge jurisdiction and that he was not allowed to do so. The prosecutor is stating that there was only a proceeding at an arraignment and that the prosecution hasn't even got to the point where they have established whether they want to move forward with the case, but that was not allowed to happen because in their view, there was disruption in the court and there was a breakdown. The moving party is disputing that. He's saying that I could go to the video or the tapes to dispute that. At this time, the court is not going to make a decision at this point. I am going to pull the tape pull the transcript. I'm going to make a decision very quickly on this. I'm not going to let this continue. And even based on, the court does have an opinion probably on the likelihood of prosecution on a 21-year-old case. So we're going to come back on, excuse me, we're going to come back on July 6th at 10 a.m. Please check your schedule, sir.
May I also, you say July 6th, sir?
Yeah.
Okay.
Yes.
May I also, if I may, Judge?
Check your schedule first. Check your schedule to see are you available for that time.
I'm available. I'm stuck here on tether, sir. I'm available at any time you guys want me to.
Okay. All right. Well, put it on your schedule for 10 o'clock on July 6th.
Okay, can I say one more thing? If you look at Crampton versus Michigan Department of State 395, Michigan 347 at 351, it says the United States Supreme Court disqualified judges and decision makers without a showing of actual bias in situations where experience teaches that the probability of actual bias on the part of the judge or decision maker is too high to be constitutionally tolerable. And I'm not saying like trying to attack Judge Bryant or whatever else, but she has an attitude like Judge Judy. She just cuts you off. And I'm just like, so when she kept doing it, this is when I objected and asked her to recuse herself.
And sir, and again, as the chief judge, I don't have to have a showing of actual bias, but perceived bias, something in the fairness of justice. That is my stand.
Calling case number 22393437. This is Pasadena Investments LLC versus Dwayne Davis Jr. and all occupants at 2170 East Jefferson, Unit 1007.
Your Honor, for the record, Attorney Frederick J. Coleman, P. 56548 on behalf of the plaintiff. Your Honor, Mr. Davis at this time owes $6,706, court cost of $157. This is a subsequent hearing.
All right, Mr. Davis or Ms. Davis? Okay,
yeah, I'm
Davis.
I'm the beneficiary of Dwayne Davis right here. The beneficiary.
What is it?
Are you Dwayne? Are you Dwayne? Excuse me. Are you Dwayne Davis Jr.?
I'm the beneficiary owner right here.
Do you reside at 2170 East Jefferson, Unit 1007?
Yes, the estate does assign there.
Do you reside in that property?
The beneficiary, yes.
The person I'm talking to, is that the person who is in this property at 2170 East Jefferson? You're not answering my question.
I don't fully understand it. Say it again.
All right, okay. At this point, I don't see anyone who resides at 2170 East Jefferson, Unit 1007. If you do reside there, please make the court aware of it.
Okay.
Your Honor, since the defendant has not identified himself as the defendant in this particular matter.
I just did. I just told you I'm the beneficiary.
Your Honor,
of the name.
Your Honor, since the defendant has not identified himself as a person in this property, he's attempting to try to act like he's a sovereign. This property is owned and is an apartment building. We're asking for a default judgment at this time. If he decides to pay it, that's great. If not, we'll be moving forward after time expires.
Before we proceed with this matter, can I ask the director of the beneficiary? I'm talking to the plaintiff, sir. My legal person, I'm showing you right here, a corporation. Can you write me in 21 days and provide me evidence that you have legal?
Your Honor, none of that is required by law in this court. I'm asking for a default judgment this time. Quit wasting the court's time. If he wants to file the appropriate court paper or identify himself to the court as you've requested on numerous occasions, then we can proceed forward. At this time, playing these legal games is against. I
have a birth certificate right here.
Against the law. Two, we provide the court with a lease agreement. We provide the court with the ledger. We're asking for a default judgment.
The court is in receipt of a summons, a complaint, a demand for non-payment of rent, as well as a lease agreement.
The summons was never notarized.
Signed with Dwayne Davis Jr., as well as a proof of service. Mr. Davis, Dwayne Davis Jr., how much is your monthly rent?
I want to say 900.
When's the last time you paid rent?
Long time. Siri paid my back balance, but Pasadena never put it to my account. So I consider Pasadena either took the money or what. I don't know what they did with it, but Siri definitely paid it. It's on the record. It's on my the record with the Siri. You can find it in their profile. But they're supposed to pay my back balance.
I don't know. I can't find it in my profile. So you qualify. Sarah paid. How much did Sarah pay?
They paid up to like September, but they didn't pay they're supposed to pay July, August, September, but Pasadena never put that to my account.
Your Honor, if it wasn't applied, my client didn't receive it. That is not our burden.
Okay.
It's his burden.
But that's in documents though that they were supposed to pay. I have it in documents.
Your Honor, I'm not going to sit up and argue all day, Your Honor. Bottom line is, the money is for his benefit. It is not for my client's benefit. Just like paying a mortgage payment. If I send a mortgage payment in, if it's not received, it's still on me. If you send a mortgage payment on my behalf and it's not received, it's still on the person who has the mortgage. He's the renter. It is his responsibility to have the money paid, or to whoever's paying on his behalf, that we receive it. We have done everything we're supposed to do. The documentation speaks for itself. At this time, again, I'm requesting for either default judgment or judgment by hearing.
And then I'm talking to the plaintiff. Can you just write me and saying that you have authority as a public servant to me?
Your Honor, I am not writing.
Excuse me,
I'm not
Mr. Davis. This is a landlord-tenant court. This is summary proceedings. This is the second hearing, and you're afforded legal counsel. Legal counsel was available. They said that they could not assist you at this matter. Are you even identifying yourself as Dwayne Davis Jr.?
No, I'm the beneficiary of that name.
So are you not Dwayne Davis Jr.?
No, I am not. I am not.
Okay. We are entering. The court has not received the call or answer from Dwayne Davis Jr. Does anyone on this Zoom reside at 2170 East Jefferson, number 1007? Is anyone present who lives in that property on this Zoom?
Your Honor, again, no one's responded, asking for my default judgment. We can submit it to the court before the end of the day, along with a full ledger.
Default judgment granted.
Thank you, Judge.
Please submit the paperwork. Colin, you're free to leave. Well, nobody identified themselves, so calling the next case.
Good morning, Your Honor. Yeah.
Good morning, everyone.
Good morning.
Are you ready on the motion for Michael McCreary?
Yep.
All right, the clerk can call the case.
2356485, the people of the state of Michigan versus Carnell Michael McCra. Mr. McCra is charged with count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm less than murder or by strangulation. Count 3, weapons, firearms, possession by a felon. Count 4, weapons, ammunition, possession by a felon. Count 5, assault with a dangerous weapon, felonious assault. Count 6, 7, 8, 9, and 10, weapons, felony firearm. With the habitual offender fourth defense notice set for a preliminary examination today. Before the exam, there was a motion that was filed by Mr. McCray to disqualify me from this case, and that is why Chief Judge McConico is on Zoom to address that motion.
Okay, appearances.
Edwin Sawaki, P54A2A, appearing on behalf of the people.
Carnell Michael McCra, natural person, not a corporation, natural flesh and blood.
Okay, thank you. Thank you for your appearances. The court did receive a motion to disqualify Judge Elias Abri pursuant to MCR 2.003. The court having considered the pleading and being otherwise fully advised on the premises, the defendant having moved to disqualify Judge Sabri, but having stated no grounds that meet the legal basis under MCR 2.003 that would demonstrate that the judge has shown actual bias against the defendant or defendant's attorney. It is ordered that the motion to disqualify Judge Sabri is denied. This order does not resolve all pending claims as to the remaining parties and does not close this case. So the motion is denied. Thank you very much.
And Attorney Washington, I know you want to put your appearance.
Oh, yeah, I'm sorry. Yes, Earl Washington as the backup attorney.
May I speak, Judge?
That matter.
Now that matter is resolved now. The court is turned over back to, excuse me, sir. The motion was denied. And now the court is being turned back over to Judge Sabri to handle the preliminary examination. Thank you very much.